Hey there, folks. Welcome back to Patrick Kelleher, your elder law care attorney. And this is part 2 of our 3-part program teaching you how to protect what you have for the people you love the most, from whom, you should know by now, folks, from the four-headed monster of estate planning and elder law. Part 1, you recall, we learned how to protect what you worked hard for from probate court, the first-headed monster. 2 types of probate court, death probate. 4 reasons you learned in part 1 of the webinar, how to avoid probate court. And then we learned the second part of probate court, which is often overlooked. That is disability planning or disability probate. I did an article in South Shore Senior Newspaper, the Big 6 Disability. I added a 7th disability planning tool to the toolbox, and now we call it the Big 7 Disability Plan. Folks, this part of the program, we're moving on to the second-headed monster, the estate death tax. And then we're going to move on to the third-headed monster, which is financial creditors and predators. And we're going to teach you how to protect against those 2-headed monsters. All right, folks, let's jump right into it. Second-headed monster. What is it? It's estate tax. What you ought to know, there's 2 types of estate tax. There's a federal estate tax, and there's a state estate tax in some states, okay? Like here in the Commonwealth, Massachusetts. Massachusetts is one of about 13 states that still has a state estate death tax. And a lot of our clients who are middle-class millionaires, when you add up your gross estate, they're over $1 million. A CPA told me recently, if you're $1 over here in Massachusetts, it's about $18,000 owed to the taxing authority, the Massachusetts Department of Revenue, because we have an estate tax here in the Commonwealth currently. There's about 13 states in the country that still have a state estate tax, and Massachusetts and Oregon are leading the pack with the lowest threshold at $1 million each. If you live here in the Commonwealth, that's a state you need to be concerned about. Massachusetts, that still currently has an estate death tax under current tax law at the time this program is being created. So you really need to keep an eye on that, folks, because that's a second-headed monster right here. And we're going to talk about some ways a married couple can protect from the estate death tax with marital planning or estate tax planning for married couples. A trust, B trust, tax credit sheltered bypass trust. Bypass trust is typically the operative word that you'll hear in the industry that will help you minimize or avoid the estate tax to the greatest degree possible. Some of my colleagues call the estate tax the only voluntary tax that you have to pay, meaning that if you do proper planning when you're alive and well, and you put proper estate tax planning language and formulas in your estate plan, that you can avoid or minimize the estate tax to the greatest degree possible. So you got to think about that in your why. Who do you want to be the beneficiary of everything you worked hard for? Do you want it to be the tax man, or do you want it to be your loved ones? A lot of my clients will say, hey, Patrick, we feel we paid enough taxes in our lifetimes, and we're going to talk about the different types of tax shortly as well. And they'll say, if there's a way that we could legally, permissibly reduce our estate tax obligation, we're interested in learning how to do that. We want to make sure that our estate elder law attorney drafts the appropriate language in our trust plan to minimize or reduce or avoid the estate tax to the greatest degree possible. That's the second-headed monster. And then we're going to jump on to the third-headed monster, which is financial creditors and predators. Show of hands, how many folks worked hard for what you have? Raise your hand nice and high so I can see it, okay? A lot of our folks, when they attend our live events, they all raise their hand. Everyone feels, as my dear parents did, they worked hard for what they have, okay, or what they had. And they typically want to do the 3 Ps. We talk about that in the book. They want to protect, they want to preserve, they want to pass on what they worked hard for the people they love the most, and that is their why, okay? They want to create that legacy, that lasting legacy. So they have that peace of mind. They're on the front side of their cloud, looking down at their loved ones on a beautiful blue sky day, and their loved ones are still getting along, still talking, and they're singing and rejoicing your remembrance. They're honoring their parents or grandparents in some situations. So folks, think about all that. So we're going to talk about the second-headed monster, the estate death tax, federal and state. We're going to talk about financial creditors and predators, how to protect your assets from times of turmoil, automobile accidents, lawsuits, creditors, divorces, in-laws turning into outlaws, and the casserole brigade. You're going to learn about the casserole brigade and Betty the barmaid leading the parade in the casserole brigade. You're going to learn about Bo the tennis pro. You're going to learn about Mo, Larry, and Curly, your loved ones, and how to protect a whole lot of them with the proper asset protection. Do you know why, folks? Because from my experience, most estate plans are, as you know, a stack of documents. They have insufficient asset protection language in there from my experience most of the time. Most of the time. Wills will typically always say, or most of the time say, from my experience, when mom and dad are gone, if it's a straight, simple will, like most wills that I review, it'll say everything goes to the children outright. You're giving them a gift, but it's not a protected gift. You're giving them a distribution in the palm of their hands. They run into any times of turmoil, lawsuit, divorce, automobile accident, bankruptcy, you name it. Take your pick your poison. Then 100% of their assets, their inheritance, is exposed to financial creditors and predators. Also, folks, a lot of trusts that I review will have these three problematic words in the trust. After mom and dad are gone, everything goes to their lovely children, free of trust or free from trust. Again, it's an outright distribution in the palm of their hands. The problem with that, from my experience, you're giving them a gift, but not a protected gift. So a lot of our clients will say, hey, Patrick, we work hard for what we have. How do we give a protected gift to our loved ones? I have 3 children. I love them dearly. Their names are Mo, Larry, and Curly. How do I protect my Mo, Larry, and Curly from times of turmoil? Divorces, motor vehicle accidents, bankruptcies, you name it. Bad decisions, gambling. Some of us call it the hit parade. Maybe it's alcohol. It could be maybe mental illness. Whatever the situation may be. You're the expert on your family. You want to work with your estate elder law attorney in confidence and share your expertise in family dynamics with your attorney. It's the attorney's job to educate you and inform you about the law. And the deal is you work together to co-create and customize your plan to meet your dream snapshot. So when you're up in your cloud someday, you met your vision, your goal, your dreams, your aspiration. And your family's singing your praise. That's the front side of the cloud right there, folks. So whatever that may be, you want to put that proper language in your trust is my recommendation to protect from the third-headed monster, which is financial creditors and predators, okay? And that is certain language that needs to be drafted into the trust so that you are giving your loved ones better than a gift. You're giving them what I refer to as a protected gift, a protected gift. We're going to learn how to do that momentarily. So stay tuned. All right, folks, let's get started here. The estate death tax, the second-headed monster in the book right here. Again, if you haven't received the book yet, you can always pick up a copy on Amazon. Being a student of my program, if you become a student of our 5-part program, which takes a deeper dive on estate planning in elder law, you do receive a complimentary copy of the book. If you are a client of our elder law care firm, we also make sure you receive a complimentary copy of the book as well. If you just want to get a copy yourself, you can certainly go to Amazon and get a copy, pull it right off Amazon and have it sent to your home or your work, and you'll be reading the book in no time, which is a nice supplement to the education that you're receiving here today. 2 kinds of estate tax, folks. Let's do an overview, okay? Federal estate tax is currently 11.58 million, okay, under current tax law, okay? Folks, that's a big number, so my clients who don't have more than 11.58 million, they don't have to worry about the federal estate tax under current law, but it's a moving target. It's always changing. I've researched the estate tax law. It's been around since World War I, and it hasn't really gone anywhere, and it doesn't seem like it's going to go anywhere. Why, folks? Because it's a great revenue generator for whom? Congress. That is correct. For the government. The government utilizes the estate tax when people pass away. They collect money from their estate in certain circumstances when they exceed the estate tax threshold, and they utilize that money for their social programs, okay? So the estate tax now is 11.58 million per individual, indexed for inflation. It's scheduled to go up next year, and then it's going to sunset in the year 2025. It's going to go back down to 5 million in 2025. And who knows what can happen between now and then, because this is an election year, and whether it's the Democrats in the White House or the Republicans, they're always tweaking the tax code. So you need to really keep an eye on it, and that's one of the changes in law, one of the 3 L's that I often talk about and educate our students and our clients about. So you need to keep an eye on the estate tax. Most of our clients don't have to worry about the federal estate tax, but I do want to inform you and educate you about it because you ought to know. And this federal estate tax, again, 11.58 million now, lifetime exemption, indexed for inflation. And for a married couple, there's a thing called portability, meaning that you can use your deceased spouse's unused exemption amount, okay? You can use your deceased spouse's unused exemption amount and add that to your 11.58 million if your deceased spouse uses a portion of their 11.58 million. They call that DSU, deceased spouse's unused estate tax exemption amount, okay? DSU, deceased spouse's unused exemption amount. That's just an acronym, so folks know what to do when the deceased spouse passes away. They use, or their accountant uses, their estate tax exemption amount. Anything left over, the surviving spouse can claim. They have to claim that typically within 2 years from the date of death by filing what they call a 706 estate tax return. So you want to file that estate tax return on the current tax code within 9 months from the date of death. And that seems like a long period of time, but from my experience, folks, most folks, surviving spouses, children of the deceased parent, are not running off to an attorney's office the day or a week after their parent passes away. They're grieving, they're going through the mourning process, they're taking care of family affairs and funeral matters and so forth. They may show up at the attorney's office 3 months, sometimes 4, 5, 6 months after the passing of their loved one. And then the attorney or the accountant only has 3 months or a short period of time to file, prepare, review, and file that estate tax return. Really, really important to know that under current tax code, you have 9 months from the date of death to file an estate tax return. If you file it late, the Internal Revenue Code can charge interest and penalties. You also ought to know that there's a one-time extension you can get for 6 months beyond the 9-month required period. 2-year period is for when you are filing for what they call portability. When you're getting the DSU, the deceased spouse's unused exemption amount, if you need to use that, okay? All right, so there's some important deadlines that you ought to know around the estate tax. So you might be thinking, hey Patrick, we don't have a federal estate tax, we don't have to be concerned about that. But let's talk about the state estate tax. A lot of our clients are what I refer to as middle-class millionaires here in the Commonwealth and of Massachusetts. Massachusetts has an estate death tax set at $1 million, pretty low threshold. And I'm not talking $1 million cold cash that you're sitting on. I'm talking about your gross estate, the value of your home, your retirement, your 401k, your 403b, your IRA, whatever you may have. Add it all up together, your personal property, your boats, your trains, your automobiles, your campers, your jet ski, whatever you may have that's titled in your name, where you have incidents of ownership, that's computed into your gross estate. So if you're $1 over, again, it's about $18,000 owed here in Massachusetts. Mass, the estate tax is $1 million. It equals about 18 grand to the DOR, Department of Revenue, okay? So if you have a standard will and you're a married couple, okay, Bill and Mary, simple will, $500 will typically will give you about $500 worth of protection, okay? So Bill and Mary, simple will, stack of documents, they have a $2 million estate, okay? A will typically is woefully insufficient to properly protect your affairs in your family. $2 million estate, Bill checks out. Sorry, gentlemen, statistically, from an actuarial standpoint, they say us men usually die first, and looking around at the students here today, most of you men look like you do what you're told. My dear dad did what he told. He was older than my mom. My dad passed away first. And the actuarial statistical data says that most men pass away first. Not always, but the majority of the time. So Bill checks out first with a simple will, and he leaves everything outright to his bride, Mary, okay? Mary gets a $2 million. But if Bill fails to elect his coupon, his $1 million exemption coupon here in the Commonwealth, then Mary gets everything outright. And if Bill fails on the tax law to elect, or his accountant fails to elect his $1 million coupon, it's lost forever. So when Mary passes away a short time later, usually they're married 50, 60 years, and usually it's not a long time after the husband passes away, Mother Teresa calls, Mary checks out with a $2 million estate. On the current tax code, Mary only has a $1 million exemption, a $1 million coupon. So Mary can only use her $1 million coupon under her will without proper estate tax planning to apply towards her $2 million estate. So that's going to be taxed at the applicable estate tax rate here in the Commonwealth. So she can use her $1 million coupon, but she died with a $2 million estate because her husband didn't have the proper planning in the will-based plan, and the family likely is going to pay tens of thousands of dollars in estate tax. Okay? Now, if they had proper planning with estate tax planning in there with bypass tax credit shelter trust, they could look to avoid or minimize the estate tax to the greatest degree possible. We'll talk a little bit about that as well. The important thing to remember here, folks, is if you are married and you have potentially a taxable estate, and I want you to do an exercise, write everything down, because from my experience, a lot of folks are like, I don't have $1 million. And again, I want to stress, I'm not talking about $1 million cold cash. You have to add everything up. The value of your home, your retirement, your bank accounts, your investment accounts, your personal property, your life insurance. That's a biggie. Life insurance is typically what I refer to as an invisible asset, because a lot of people overlook it like they can't utilize it. It's not a benefit to them during their lifetime. But the Internal Revenue Code says this: if you have what they call incidents of ownership over that life insurance, they compute the death benefit value of that life insurance into your gross estate for taxable purposes. I've had a lot of cases where folks appeared to be under the million, but they had a big life insurance policy, $250,000, $500,000, and it puts them over the $1 million. Okay, so I give you this illustration here. The $500 will give about $500 worth of protection. Now the family is likely paying tens of thousands of dollars in estate tax. And that's why some of my colleagues call the estate tax the only voluntary tax that you have to pay, okay? So let's go back to some ways on how to avoid the estate tax. Let's go to Bill and Mary now. They have a trust, okay? This is a revocable trust. We call ours at our Elder Law Care Center a Revocable Asset Protection Trust, or a RAPT, okay? So it's a revocable trust, but it has a good amount of asset protection language in there to protect from the third-headed monster, financial creditors and predators, okay? So a RAPT right here for Bill and Mary. Same scenario, $2 million estate. When Bill checks out, their trust is going to have what I call magic tax language in there. And we often refer to the marital trust as an A trust and the bypass trust as a B trust, okay? So what they can do is put their $2 million estate, they can put the exemption amount here in the Commonwealth, $1 million, into the bypass trust, okay? And Mary, the wife, can be the trustee manager of that money, as well as the beneficiary to receive income during her lifetime, okay? When Mary checks out years later, that money should go down to whom? The children. Estate tax free, because the money was in a bypass trust, okay? So the other money, the excess money, the other $1 million, goes into the marital trust. Mary is also the trustee of the marital trust, and guess what? She's also the beneficiary of the marital trust as well. When Mary checks out, if she doesn't spend all that $1 million, likely the children will be the beneficiary of the marital trust, okay? So the bypass trust is a trust that derives the tax benefits, the tax protection. Some other names that you'll hear in the industry for a bypass trust would be a family trust. Some folks refer to it as a credit shelter trust, and oftentimes you'll hear it referred to also as an exemption trust or a bypass trust, okay? Again, folks, this is a kind of a simplistic example of how you can create estate tax planning protection for a married couple within their revocable trust, okay? So whether you have a taxable estate or not, if you're getting close to that threshold, I recommend to folks to still create this language in your trust-centered plan, because it's a nice sweater in the suitcase should your assets appreciate in value as you journey through life, okay? I often say the day you sign your plan is important, but what's the most important day you need your plan to work? That is correct. The day that Mother Teresa calls or St. Peter calls. And the tricky thing is none of us know that date on the calendar. So you want to make sure you have that proper tax language in your plan to take advantage of the estate tax planning that the Internal Revenue Code provides. And you want to work with a qualified estate planning and elder law attorney that's familiar with the language and drafts the appropriate language into your plan, okay? Folks, let's talk about some other ways that you can minimize other taxes that you ought to be familiar with. Most of us are familiar with the income tax, but there's all different kinds of taxes. And we're going to do a brief overview of the different types of taxes, because this too can be one of the headed monsters. The second headed monster is the estate tax. But these are all the cousins of the estate tax, and you ought to know about them and work with a qualified accountant, CPA, or tax attorney if you have concerns or questions relative to these different types of taxes, because it could save your family and yourself a lot of money if you do the right things. So other types of taxes, well, we just talked about the estate tax. We talked about the federal estate tax. Each individual taxpayer currently gets $11.58 million over their lifetime. Married couples can double that, $23.16 million for a married couple under the portability laws under the current tax code, okay? That's a lifetime exemption for the estate death tax, okay? There's a thing called the gift tax as well. The gift tax is typically equal to the federal estate tax amount. So under current law, every taxpayer has a lifetime gift tax exemption equal to the federal estate tax amount, which is $11.58 million, indexed for inflation. This means, folks, that you could give away up to $11.58 million without paying a gift tax, okay, if you had that much money. So really, really important to know that. While we're speaking about the gift tax, it's also important to know if you exceed a gift of more than $15,000 under current law in a given calendar year, you will have a legal requirement to file a gift tax return called a 709 return. Okay? So if you exceed $15,000 giving someone a gift, you will have to file a gift tax return. You may not owe any gift tax because you have a lifetime exemption under current law of $11.58 million. But if you exceed $15 million, there's a legal requirement to file that gift tax return. And there's things like called split gifts. A husband and wife can double up their gift, turn into $30,000 if they're both giving a gift to their son or their daughter. And then if you're giving $30,000 to your son or daughter, and then you're giving $30,000 to the in-law, you can get it up to $60,000 and so forth and so forth. But I did an article in South Shore Senior News a couple of years ago called "Gifting is a Double-Edged Sword." Don't ever engage in gifting, folks, unless you're working with a qualified attorney, qualified accountant, CPA, and let them walk you through the process, and don't make gifts willy-nilly until you consult with a proper professional before you write that check. Really, really important to do that to make sure you're crossing the T's and dotting the I's, okay? So that's my disclaimer to you. Don't do it yourself. Work with a qualified professional before acting on that. But these are ways to spend down your estate, okay? So other types of taxes, folks, there's a thing called the income tax that you're familiar with. But what you may not be familiar with is there's all different levels and brackets of income tax, okay? So under current tax code, I'm going to share with you the current different income tax brackets based on your income, okay? So you have income tax at 10%, 12%. We have 22%, 24%, and then we jump up into the 30s. We have 32%, 35%, and the top tax rate under current tax code is 37% for the highest income earners, the people making about $500,000 or $600,000 a year. they're going to get the highest tax bracket right there. Okay, so that's the income tax, folks, that a lot of you are familiar with, but different tax rates based on your income. Okay, folks, capital gains tax. What is capital gains tax? Capital gains tax right here is typically when you're selling an asset. A lot of my clients are concerned about capital gains tax when they're selling their home or a piece of real estate. So the tax code for selling a home is typically under section 121 of the code, okay? And what it says is this, folks. Each taxpayer gets a $250,000 exemption when you're selling your principal residence, okay? So each taxpayer gets a $250,000 exemption or coupon when you're selling your principal residence. There's some conditions attached to that. It has to be a principal residence. You have to live there 2 years out of a 5-year period. Live there 2 years as your principal residence out of a 5-year period, okay? You don't have to roll it over and buy another house for a greater value. That's the old capital gains tax rule that a lot of folks still are a little familiar with and get a little confused about, okay? So under the current capital gains tax rules, section 121 of the code, you don't have to roll it over. You can sell your home and you get a $250,000 exemption coupon from your basis. You can add that coupon in there as a cushion, and if you're not over what you bought the house for as your basis, then you add that $250,000 coupon. If you sell it for not more than that, then you likely won't have a capital gains tax, okay? Married couples, listen up very, very closely because you get an added benefit other than helping each other cook and clean around the house and share domestic duties and chores. You get some tax benefits being a married couple. The estate tax is one of them. The capital gains tax is another one. A married couple can double their coupons, provided that you're filing your income tax married filing jointly. Married filing jointly, and you can double that $250,000 to $500,000 for a married couple when you're selling your home. So if Bill and Mary, I'll give you an example, purchased a home for $200,000 30 years ago, their tax basis is $200,000. Many years later, they're selling their house for $700,000. They paid $200,000, they're selling for $700,000. They're selling an asset, and the difference between 7 and 200 is how much? That's correct, 500. You're thinking, holy smokes, they're going to get zonked with a big capital gains tax bill. Not so under current tax code. Section 121 will give Bill and Mary a $500,000 coupon, provided they're filing their tax return married, filing jointly, and provided they're meeting the other conditions. They live there 2 years out of a 5-year period and so forth, and it's their principal residence, 2 years out of a 5-year period, filing tax return, married, filing jointly. They should get the $500,000 coupon, and that way they're selling the house for $700,000. They should have zero capital gains tax when they're selling that property. Really important to know that. All right, folks, we're going to talk about GST. What is GST? GST is generation skipping transfer tax. So a lot of our clients will say, hey, Patrick, my kids are pretty well off, and I want to give something to my grandchildren. I want to skip a generation, and I want to give something to my grandchildren. So whenever you might be skipping your children as a beneficiary in your estate plan and giving something directly to your grandchildren, you want to be thinking GST, because the taxing authority can charge you a generation skipping transfer tax. The generation skipping transfer tax right now is also equal to the federal estate tax amount, which is $11.58 million. However, there's no portability for the generation skipping transfer tax. You cannot double that, okay, for a couple. $11.58 million for the generation skipping transfer tax. Folks, moving on here to this tax right here. It's very an unusual tax. It's very unusual circumstances. Usually don't see it around very much. It's called income with respect to decedent, or IRD is what they call it. So income with respect to decedent, and this tax might be a situation where if somebody was selling their property and the property was under contract with a purchase and sale agreement, and say the real estate closing was going to happen 4 weeks out into the future, and the seller of the property passes away. And if the property still sells, there might be a situation where there's tax owed called income with respect to the decedent. So the beneficiaries of that property would have to pay what they call an IRD tax, which my understanding was typically equal to the beneficiary's income tax level or income tax rate, okay? So folks, there you have it. You have an overview education on different types of taxes other than the estate tax. We talked about the income tax, capital gains tax, generation skip and transfer tax, income with respect to decedent, and we talked a little bit about the gift tax as well. With the lifetime exemption of $11.58 million on the current tax code, you can make gifts up to $15,000. If you exceed $15,000, you have to file that 709 gift tax return. That's your legal obligation. Again, folks, this is not do-it-yourselfer stuff. This is something you want to work with a qualified estate planning or elder law attorney or a qualified CPA or a tax attorney when you're making any gifts or dealing with any of these tax matters. Really, really important to know that because you need to cross the T's and dot the I's. All right, folks, we're going to talk about some other ways to minimize the estate tax, okay?